I never thought I'd spend my retirement fighting a $1 billion corporation in a Montana courtroom. But that's exactly what happened. And it started on a Tuesday morning when my neighbor Jim Holt showed up at my door looking like he'd seen a ghost. My name is Ray Calloway, retired contractor, Billings, Montana, and the 600 acres behind me has been in my family for 61 years. My grandfather Earl bought the first parcel in 1963, paid cash. 200 acres of grassland most people thought wasn't worth the price. Earl wasn't speculative. He bought it because he believed a man who owned his land owned something no one could take from him. He was almost right about that. My father Gene added another 240 acres in 1979, paid off the loan in 6 years. By the time I was 12, I knew every fence line, every creek bend, every patch of rocky ground on this property the way most kids know their own backyard. When my father passed in 2009, it came to me. Clean title, no mortgage, no dispute. I had it surveyed that same year, filed everything properly with Cascade County, and spent the next decade taking care of it the way my father taught me to. I retired in 2019, fixed up the main house, rebuilt the outbuildings, put in a new well on the north parcel. By 2021, this land was in the best shape it had seen in 30 years. This is what I want you to understand before I tell you the rest. This wasn't just property to me. This was 61 years of my family's work. My grandfather's calloused hands, my father's 6-year loan, my own sweat poured into every fence post and outbuilding on this land. A billion-dollar Denver developer saw none of that. They saw a corridor, a line on a map, an obstacle between them and a private road they'd already planned, already sold to investors, already announced at county commission meetings I was never invited to. And while I was fixing fence lines and drinking coffee on my front porch, they were already filing. I just didn't know it yet. It was a Tuesday morning in early October. I was out on the north parcel checking a section of fence line that had been giving me trouble since the first frost hit. Nothing dramatic. 2 posts had shifted, the wire had gone slack. 20-minute job. The kind of small maintenance work that keeps a property from unraveling one loose staple at a time. I heard Jim's truck before I saw it. He drives an '09 Ford F250, dark green, one side mirror held on with electrical tape. I've heard that engine 1,000 times, pulling up to share a cup of coffee, dropping off a part he'd picked up in town, stopping by just because the road goes past my place and he had no reason not to. Jim Holt is not a man who shows up uninvited with bad news. In 20 years, I could count those times on one hand. This was one of them. He parked at the gate and didn't honk, just got out and stood there waiting for me to walk over. That alone told me something was off. Jim always honks. I set down my wire stretcher and walked across. He had an envelope in his hand, standard white, already opened, slightly crumpled the way paper gets when someone's been holding it too long. He held it out without saying anything at first, just watched my face. "Got this 3 days ago," he said. "Didn't know what to make of it. Showed it to my son-in-law last night. He's in insurance, not law, but he said you needed to see it." I took it. The letterhead read Apex Land Holdings, Denver, Colorado. Below that, a block of dense legal language that I had to read twice before any of it started making sense. It referenced Jim's property, but only in passing. Most of it referenced mine. Parcel numbers I recognized. Boundary coordinates I knew by heart. The letter was addressed to Jim, but it was about my land. The phrase that stopped me was near the bottom of the second paragraph. In connection with the prescriptive easement filing currently recorded against the above-referenced parcels. I read it again, then a third time. "What's a prescriptive easement?" Jim asked. "I don't know exactly," I said, "but the words filing and recorded mean somebody put something on paper somewhere." I folded the letter, put it back in the envelope, and handed it to Jim. He told me to keep it. I didn't argue. I drove back to the house, sat down at the kitchen table, and did what any person does when they don't understand something legal. I searched it online first and called the county second. The search was not reassuring. A prescriptive easement, in plain terms, is a legal claim that says a person or entity has been using someone else's land, openly, continuously, without permission, for long enough that the law starts to recognize that use as a right. It's the kind of thing that applies to old footpaths, shared driveways, access roads that have existed for decades without anyone formalizing them. It is not supposed to apply to 600 acres of private land with a clean title, a recent survey, and a locked gate at every entry point. I picked up the phone and called the Cascade County Recorder's office. The woman who answered was polite, professional. I gave her my name, my parcel numbers, asked her to tell me if anything had been filed against my property in the last 2 years. There was a pause, longer than it should have been for a simple records check. "Mr. Calloway," she said carefully, "I'm showing 3 active filings associated with parcels under your name." I kept my voice level. "What kind of filings?" Another pause. "An easement claim, filed by an entity called Apex Land Holdings out of Denver. It covers parcels 7, 9, and 11 on your Cascade County record." Parcels 7, 9, and 11. I knew exactly what those were without looking at a single document. Parcel 7 was the Northwest Meadow, the best grazing land on the property. Parcel 9 ran along the main access road from the county highway. Parcel 11 was the long diagonal stretch that connected the northern and southern halves of my land. Together, those 3 parcels formed a continuous corridor, a road. "When was this filed?" I asked. 14 months ago, she said. "September of last year." 14 months. I had been out here for 14 months, fixing fence, rebuilding outbuildings, putting in that new well, while a Denver corporation had an active legal filing sitting on 3 of my parcels at the county recorder's office. "Was I notified?" I asked. She hesitated. "A notice would have been sent to the address on file." "What address is on file?" She read it back to me. It was my address from 2012, a rental house in Billings I had lived in for 8 months before moving out here permanently, an address I had not used, received mail at, or been associated with in over 11 years. I thanked her and hung up. I sat at that kitchen table for a long time after that. The October light was coming through the window at a low angle, cutting across the floor the way it does in the fall out here. Somewhere out on the property, a hawk was calling. Everything looked exactly the same as it had that morning, but something had shifted. I could feel it. 3 parcels, my parcels, filed on 14 months ago, and nobody told me. I didn't sleep that night. I lay there running parcel numbers through my head like I could solve something by memorizing them. 7, 9, 11, the Northwest Meadow, the access road strip, the diagonal connector. I kept thinking about that address, my old Billings rental, a place I hadn't set foot in since 2012, and how it ended up on a legal filing in 2024. Mistakes don't work that way. Clerical errors don't require research. By 5:30, I gave up on sleep, made coffee, and waited for the courthouse to open. Cascade County Courthouse opens at 8. I was in the parking lot at 7:45. The clerk at the land records window was a younger man, mid-30s, efficient and businesslike. I gave him my parcel numbers and asked to see the full filing. He disappeared into the back for about 4 minutes and returned with a document packet roughly an inch thick, set it on the counter, and told me I could review it at the reading table against the far wall. I sat down and started reading. The filing was titled, "Notice of Prescriptive Easement Claim, Apex Land Holdings, LLC versus Callaway Property Trust, Cascade County." 14 pages of legal language, exhibit attachments, and parcel maps. I am not a lawyer, and I want to be straight with you. I did not understand all of it, but I understood enough. Apex Land Holdings was claiming that they, or their predecessors, had been using a continuous corridor across parcels 7, 9, and 11 for access purposes for a period exceeding 5 years. Under Montana law, if that claim held up, they could be granted a legal right of access across my land, permanently, without my consent, without compensation. The claim was dated September 11th of the previous year. I flipped to the service exhibit, the page showing how and where notice had been delivered. There it was, the Billings address, printed clearly, no ambiguity. But here is what stopped me cold. Attached behind the service exhibit was a property research summary, a document Apex's legal team had prepared showing their due diligence on my parcels before filing. It listed the current survey date, the current deed holder, the current assessed value. All of that information was current. All of it reflected my actual present situation. But the notice address was from 2012. They had found my current survey. They had found my current deed. They had found my current assessed value. They had not accidentally used an old address. They had deliberately gone looking for one. I sat at that reading table for a long time. Then I drove home and opened my laptop. Apex Land Holdings wasn't hard to find. They had a professional website, clean, corporate, the kind of site that uses words like visionary and transformative without any apparent embarrassment. Headquartered in Denver, founded in 2004. Active development projects in Montana, Wyoming, Idaho, and Colorado. Their portfolio page listed luxury resort developments, private residential communities, and what they called integrated access corridor projects, which, as far as I could tell, meant private roads connecting their various properties, built across land they either owned or had obtained rights to. I kept reading. There was a press release from 18 months ago, 4 months before they filed on my land. Apex had presented a development proposal to the Cascade County Commission for a project called Ridgeline Reserve, a private luxury resort and residential community on 1,200 acres they had already acquired in the northern part of the county. The project included, and I am reading directly from their press release here, a private access corridor connecting Ridgeline Reserve to the county highway system via an existing land corridor in the Central Valley. I pulled up a county parcel map on my screen, the Central Valley. I found Ridgeline Reserve's location on the northern acreage. I found the county highway to the south. I drew a straight line between them in my head. That line ran directly through parcels 7, 9, and 11. My northwest meadow, my access road strip, my diagonal connector. They hadn't stumbled onto my land. They had planned around it. Their resort was already designed, already announced, already moving through the permitting process, and my 600 acres sat squarely between their property and the road they needed to make the whole thing work. I went back and found the county commission meeting minutes from 18 months ago. Apex's presentation had been well received. 2 commissioners had asked questions about the access corridor. Apex's representative had told them, and again I want to be precise here, that access rights for the corridor were in the process of being secured through standard legal channels. Standard legal channels. 14 months ago they filed on my land using an 11-year-old address and called it standard. I kept digging. A local news article from 8 months ago. 2 months after the filing, 6 months after their commission presentation, quoted an Apex spokesperson saying the Ridgeline Reserve project was on track, that infrastructure planning was proceeding, and that they expected to break ground within 18 months. The article mentioned that private road access had been largely resolved. Largely resolved. I was sitting right here on this property when that article was written. I had no idea any of this existed, and somewhere in Denver, a spokesperson was telling a Montana newspaper that access to my land had been largely resolved. The picture that was forming was not complicated once you saw all the pieces together. Apex had identified my land as the necessary corridor for their resort access road. They had decided at some point that approaching me directly was either too expensive, too uncertain, or too slow. So instead, they had filed a prescriptive easement claim using a bad address, giving themselves a legal foothold while ensuring I would never receive notice. If the claim sat long enough without challenge, it could mature into an enforceable right. If I eventually found out and objected, they had enough legal firepower to make the fight expensive and exhausting. And if none of that worked, they'd offer a settlement that looked generous compared to the cost of continuing to fight. It was a strategy, not an error, not an oversight. A deliberate, calculated strategy built on the assumption that a retired contractor from Billings, Montana, would either never notice or eventually give up. I closed my laptop. Outside the kitchen window, the north pasture was catching the late afternoon light, that particular gold that comes in October when the angle drops, and everything looks a little more itself than usual. Parcel 7. I had cleared 40 acres of that meadow with a rented brush cutter over 3 weekends in the spring of 2022. I had done it alone. My back hurt for 2 weeks after. They hadn't approached me. They hadn't knocked on my door. They hadn't made an offer or sent a letter to my actual address or made any attempt whatsoever to treat me like a person who had a say in what happened to his own land. They had just filed. and waited to see if I'd notice. I noticed. The next morning I called Susan Greer. I got her name from a man I'd done renovation work for back in 2018, a retired rancher named Cliff Edmonds who'd gone through a boundary dispute with a pipeline company a few years prior. He said Susan was the kind of attorney who didn't impress easily and didn't back down. In Cascade County, that reputation meant something. She agreed to meet me that Thursday. Her office was small, deliberately uncluttered. A desk, 2 chairs, a wall of filing cabinets, and a window that looked out onto Main Street. She was in her early 60s, silver-haired, reading glasses pushed up on her forehead. She read through the filing packet I'd brought without saying a word for about 12 minutes. I watched her face. It didn't move much, but at one point, the part about the old address, something behind her eyes shifted. She set the packet down. "They knew," she said, not a question. "That's what I think," I said. "I don't think it," she said. "The due diligence report is dated 2 weeks before the filing. They had your current deed information. Using that address was a choice." She tapped the packet with one finger. "This is fraudulent notice. That's your first argument, and it's a strong one." She told me she'd pull the full filing history and any associated records before our next meeting. Standard procedure before building a response strategy. I left her office feeling, for the first time since Jim had shown up at my gate, like I was standing on solid ground. She called me 4 days later. Her voice was measured, the tone of someone who has found something and is deciding how to say it. "Ray, I need you to come in." I went in the next morning. She had a second document spread across her desk alongside the original Apex filing. She let me sit down before she started talking. "When I pulled the full chain of record on your parcels," she said, "I found a co-filer on the easement claim, a secondary entity listed alongside Apex Land Holdings." She turned the document so I could read it. Patterson Land, LLC. I stared at it. "Do you recognize that name?" she asked. I did. Bob Patterson had been a neighbor. Not close, not 20-year friendship close like Jim Holt, but the kind of neighbor you know well enough to trust. Drove a white pickup. Had a place about 4 miles east. We'd shared equipment a couple of times, helped each other out in the small ways that rural neighbors do without keeping score. 8 years ago, Bob had approached me about buying a small parcel on my eastern boundary. 12 acres of scrubby land that I wasn't running cattle on and had no immediate plans for. We agreed on a fair price. I had it properly deeded, filed correctly, signed everything in front of a notary. Bob had seemed pleased. We shook hands in the parking lot of the county recorder's office, and that was the end of it. Or so I thought. "Patterson sold that parcel to Apex 14 months ago," Susan said, 3 weeks before the easement filing. I kept my eyes on the document. "And in the sale agreement," she continued, "Patterson represented to Apex that the 12-acre parcel carried with it historical access rights across the adjoining Callaway property. He described a long-standing access arrangement that he claimed had existed for years." She paused to let that land. "There was no such arrangement," I said. "No," she said, "there wasn't. I've pulled every recorded document associated with that parcel going back to the original deed. There is no access agreement, no easement, no right-of-way, nothing. Bob Patterson told Apex they were buying access to your land, and Apex used that representation as the legal basis for their prescriptive easement claim." I sat back in my chair. The room was quiet except for the sound of traffic on Main Street outside. A truck downshifting at the light, someone's radio. I had sold Bob Patterson that 12 acres for a fair price on a handshake that became paperwork. I had done it the right way because that's the only way I know how to do things. And he had taken that transaction, taken the trust that was built into it, and used it to hand a billion-dollar corporation a manufactured legal foothold on my land. "Does Apex know the access claim was fabricated?" I asked. Susan considered that for a moment. At minimum, they had a responsibility to verify it before filing. Whether they knew it was false or simply didn't care to look too hard, the practical effect is the same. I drove out to Bob's place that afternoon. He answered the door on the second knock. His face did something complicated when he saw me. Not surprise exactly. More like a man who had been waiting for a knock he'd hoped wouldn't come. I didn't raise my voice. I told him what Susan had found. I told him what his sale agreement said. I asked him plainly if he understood what he'd put in motion. He said he hadn't known what Apex was going to do with the parcel. He said he'd thought it was just a land sale. He said the language about access rights had been drafted by Apex's attorneys, and he'd signed it without fully understanding it. I looked at him for a long moment. He didn't hold eye contact. I got back in my truck and drove home. Maybe Bob Patterson was a man who'd been manipulated by a smarter and better resourced entity than himself. Maybe he'd understood exactly what he was signing and decided the money was worth it. I didn't know which was true, and I'm still not certain. What I knew was this. Apex Land Holdings hadn't found a gap in my fence line on their own. They hadn't identified a legal vulnerability through their own research and exploited it. Someone had opened the gate for them. And that someone had shaken my hand in a courthouse parking lot 8 years ago and smiled like a neighbor. Susan filed the emergency motion on a Friday morning. She called me after it was done, not to celebrate, just to inform. That was Susan's way. No false reassurance, no manufactured optimism. "It's filed," she said. "Now we watch how they respond." I asked her how long that usually took. "With a company this size," she said, "not long." She was right. The motion laid out 3 arguments in plain, direct terms. First, the notice Apex had delivered to my 2012 Billings address was not a clerical error. Their own pre-filing due diligence report proved they had accessed my current deed, my current survey, and my current assessed value before filing. All of that information reflected my actual present address. Using a 12-year-old rental address was not an oversight. It was a decision. Second, without valid notice, the filing was procedurally void regardless of whatever easement argument sat underneath it. The foundation was rotten, and the whole structure had to come down. Third, the co-filing relationship between Apex and Patterson Land LLC and the fabricated access rights Bob Patterson had represented in the sale agreement raised serious questions about whether the easement claim had any legitimate basis at all. Susan told me the notice argument was our sharpest point. "If the judge agrees that notice was deliberately misdirected," she said, "the rest collapses without us even having to argue the merits. We don't need to fight every battle. We need to win the right one." I understood the strategy. Take the foundation out, let the walls fall on their own. What I hadn't anticipated was how fast Apex would move, or the particular way they'd choose to move first. Within 4 days of Susan's filing, 3 attorneys from a Denver firm arrived in Cascade County. Jim Holt spotted them checking into the only decent hotel in town and recognized the Apex name on their luggage tags. He called me that same evening. "3 suits just landed," he said. "Matching briefcases. Didn't look like they were here for the scenery." I passed it along to Susan. She wasn't surprised. A billion-dollar resort project with permits pending and investors already committed. Of course they were treating this seriously. What she hadn't anticipated was their opening move. They didn't respond to the motion first. They called me directly. I was out on the south parcel checking the water line when my phone rang. Unknown number, Denver area code. The man on the other end introduced himself as a senior associate at Whitmore Callahan LLP, representing Apex Land Holdings. His voice was smooth and practiced, the voice of someone who makes uncomfortable calls for a living and has learned to make them sound like reasonable conversations. He said Apex wanted to resolve the matter quickly and fairly. He said they had deep respect for my family's connection to the land. He said the situation had never been intended to cause distress, and that Apex remained committed to being a good partner in the community. Then he said the number, $340,000, cash settlement, full release of the easement claim, clean paperwork, final resolution, no further litigation. I was quiet for a moment. Not because I was considering it. I was quiet because I wanted to make sure I said the next part correctly. "Did you call my attorney before calling me?" I asked. A brief pause. "We wanted to reach out personally first, Mr. Calloway. Sometimes these matters are better resolved between—" "Call Susan Greer," I said. "Her number is on every document you've received from us." I hung up. When I told Susan, she wasn't angry at me. She was angry at them. Contacting a represented party directly, bypassing counsel, was the kind of move that told you something specific about who you were dealing with. She documented it and added it to our file without saying much more about it. It was one more piece of the picture. 2 days later, Apex filed their formal response to the motion. 41 pages. Their core argument was that the address used for notice had been obtained from official research channels, and that any discrepancy reflected an administrative lag in county record updates, not intentional misdirection. They submitted an affidavit from a paralegal stating that county records had listed my 2012 address as current at the time of filing. Susan pulled the county records herself the following morning. My current address had been on file since 2010, 14 years before Apex filed, 2 years before I even vacated the Billings rental. The affidavit was wrong. Provably, documentably wrong. But Apex still wasn't done. 1 week after their formal response, they filed a secondary claim. This one alleged that my existing fence line along the eastern boundary encroached onto the 12-acre parcel they had purchased from Bob Patterson, by 14 feet in one section and 9 feet in another. They had commissioned their own survey. They were now arguing that I was the one trespassing on their property. I called Susan the moment the notification came through. "They're flipping the narrative," she said, "trying to reframe this as a mutual boundary dispute, make it look like two parties with competing claims instead of a corporation that filed fraudulently on a private landowner." I understood exactly what they were doing. The question was whether anyone else would. The answer came 10 days later in the Cascade County Courier. The headline read, "Development Project Stalled Amid Landowner Dispute." I read it twice at my kitchen table with my second cup of coffee going cold beside me. The article described Apex's Ridgeline Reserve as a project that would bring construction jobs, permanent employment, and significant tax revenue to the county. It quoted an Apex spokesperson saying they remained committed to resolving access questions through proper legal channels and hoped to move forward collaboratively. It described the project's community benefits in the second paragraph, the third paragraph, and again in the fifth. It mentioned me in the third-to-last paragraph. A local landowner has filed motions contesting the project's infrastructure access plans. The dispute has delayed permitting timelines. Local landowner. No name. No context. No mention of a filing that had been directed to an address I hadn't used in 12 years. No mention of a fabricated access rights claim. No mention of a Denver corporation that had spent 14 months quietly maneuvering around a man's property without once knocking on his door. Just a local landowner who was holding things up. I folded the paper and set it on the counter. The calls started that same week. A man I'd done renovation work for in 2017 called to say he'd read the article and that $340 was real money, and maybe I ought to think about what I was protecting versus what I was risking. He wasn't unkind about it. He was genuinely trying to be practical. I thanked him and told him I'd think on it. A woman from my father's old church sent a handwritten card. She said she was praying for a peaceful resolution, and that sometimes God puts compromise in our path for a reason. I put the card on the kitchen table and looked at it for a while. She meant well. Most people who said these things meant well. Even Jim Holt sat across from me one evening with his coffee and said it quietly, the way a man says something he's been holding for a while. "Ray, I know what this land means to you. I know it better than most. But $340 is not nothing. You could walk away clean. No more attorneys, no more filings, no more of all of this." He gestured vaguely at the table covered in documents and folders and printed county records. I looked at him for a long moment. Jim Holt is one of the best men I know. He was saying it out of genuine concern. That matters. It doesn't change anything, but it matters. "Jim," I said, "who filed first?" He nodded slowly. "They did." "Who used a wrong address on a legal document?" "They did." "Who misrepresented access rights in a property sale to give a billion-dollar corporation a manufactured foothold on my land?" He was quiet. "So tell me what I'm compromising with," I said. "Point me to my half of this problem and I'll look at it honestly. But I am not signing away land rights that my grandfather paid cash for in 1963 because a corporation made the fight expensive enough that walking away starts to look reasonable. That's not compromise. That's just losing on a longer timeline." Jim didn't argue. He finished his coffee. We talked about other things. The following Tuesday morning, Susan called. "We have a hearing date," she said. "Judge Warren Hicks, 4 weeks out." I sat down at the kitchen table. "Tell me about Hicks," I said. 63 years old, Been on the bench in Cascade County for 16 years. Before that, he practiced land and property law for 12. He grew up in Shoto, ranching family, small operation, nothing like yours, but he knows what land means to people out here. He does not have patience for procedural gamesmanship, and he does not get impressed by how many attorneys are sitting on one side of the room. Is that good for us? I asked. It means he'll read what we put in front of him, she said, which is what we need. I asked her straight. What are our odds? Susan was quiet for a moment, the particular quiet of someone choosing precision over reassurance. The fraudulent notice argument is strong, she said. The affidavit Apex submitted about county records is provably wrong, and I will make sure that is the first thing Judge Hicks understands when we walk in. The Patterson co-filing issue adds weight to the question of whether this claim had any legitimate foundation at all, and their encroachment survey has methodology problems I've already identified and documented. But, I said, this is one hearing, one judge, one shot at getting this right. Apex has 4 attorneys, a fully prepared rebuttal, and a development project with permits pending and county commission goodwill behind it. If Judge Hicks decides the address issue is an ambiguity rather than deliberate fraud, if he gives them the benefit of the doubt on intent, the procedural argument weakens significantly. She paused. I waited. Ray, if the judge doesn't see this our way, she said, Apex walks out of that courtroom with a legal road through your land. Permanently. The word sat in the room like something physical. Permanently. Outside the kitchen window, the north pasture had gone gold in the late afternoon light. Parcel 7. The 40 acres I'd cleared alone over 3 weekends with a rented brush cutter. My back had hurt for 2 weeks after. 4 weeks until the hearing. 1 judge, 1 shot. The morning of the hearing, I was up at 4:30, not by choice. My body just refused to stay asleep past that point, the way it does when something large is sitting on the other side of the day. I made coffee on the stove, stood at the kitchen window, and watched the dark over the north pasture for a long time. The kind of dark that sits heavy before dawn in October. No moon, no wind, just the outline of the ridge against a slightly lighter sky. I thought about my father. Gene Calloway was not a man who talked much about feelings or fear or the weight of things. He showed you what he thought by what he did. When the bank called in a short-term loan on the property in 1987, a loan my father hadn't expected to come due early, he didn't panic. He didn't call lawyers or neighbors or anyone. He drove to the bank, sat across from the branch manager, and laid out a repayment plan so detailed and so calm that the manager approved it on the spot. My father drove home, went out to the south pasture, and fixed a section of fence that had needed attention for 2 weeks. That was his answer to pressure. Do the next thing. Do it correctly. Don't let the size of the problem change the quality of your work. I finished my coffee, showered, put on the suit I'd worn to my father's funeral and twice since. It still fit. I looked at myself in the bathroom mirror for a moment. 54 years old, salt and pepper, the kind of face that shows its mileage without apology. I looked like what I was. A man who had spent 30 years building things with his hands, and the last several months trying to hold on to something that should never have been in danger. I drove to the courthouse. Susan was already outside the main entrance when I pulled into the lot. She had her accordion folder under one arm and a gas station coffee in each hand. She held one out when I walked up. We stood there for a moment in the cold morning air without saying much. There wasn't much left to say. We had prepared everything that could be prepared. The rest was going to happen in that room. We went inside. The courtroom was smaller than I'd expected. Wood paneling, fluorescent lighting, 3 rows of gallery benches behind the bar. The kind of room that has seen decades of ordinary county business, property transfers, permit disputes, estate hearings, and carries that history in its worn surfaces and faint institutional smell. Apex's team was already at their table. I counted them as we walked in. 4 attorneys. The lead was a man named Hargrove. I recognized him from his name on the filings. Silver-haired, broad-shouldered, the kind of man who fills a room with his stillness as much as his presence. He was flanked by 2 younger attorneys and a woman I took to be a senior associate. At the far end of the table, a paralegal had 2 laptops open side by side, matching leather portfolios, matching dark suits. The coordinated presentation of people who do this in cities where the stakes are measured in hundreds of millions of dollars and want everyone in the room to feel that. Hargrove glanced over when Susan and I came in. His eyes moved to Susan, then to me, then back to the documents in front of him. Unhurried. The look of a man who has already written his version of how the day ends. I sat down, put my hands flat on the table, looked straight ahead. Susan set her accordion folder on the table, opened it, arranged her documents in the order she'd told me she would. Notice argument first, affidavit rebuttal second, exhibit C third. She had explained the sequencing to me twice. Build the foundation before you bring out the thing that ends the argument. Don't lead with your best card. Make them watch it coming. At 9 o'clock exactly, the door behind the bench opened. Judge Warren T. Hicks walked in. He was in his mid-60s, stocky and deliberate, the kind of man who moves like he's already decided where he's going before he starts moving. Full head of white hair, reading glasses on a cord around his neck, a lined face that suggested decades of Montana winters and zero patience for anything that wasted his time. He sat down, arranged his papers with 2 precise adjustments, put his glasses on, and looked at both tables in turn. Not sizing anyone up, just confirming who was in the room. Callaway motioned to void prescriptive easement filing, he said. I've read both briefs in full. I have questions for both sides, and I'll ask them when I have them. We'll start with the motion. He looked at Susan. Counselor, you may proceed. Susan stood. She buttoned her jacket once, a habit I'd noticed she had before she started talking in any formal setting, and looked at Judge Hicks directly. Thank you, Your Honor, she said. This motion rests on 3 arguments. I'll take them in order of their weight. The room was very quiet. Outside in the hallway, someone walked past, footsteps fading. A door somewhere closed. Then nothing. Just the particular held-breath silence of a small courtroom at the beginning of something that matters. Susan began. She spoke for 19 minutes. I had heard her rehearse the core arguments twice in her office over the previous 2 weeks. I knew the structure, knew the sequence, knew which exhibits she would reach for and when, but hearing it in that room, in front of that judge, with Hargrove's team sitting 10 feet away, it landed differently. There was no hedging, no qualifying language, no softening of edges. She was clean and precise, and every word was doing specific work. First argument, notice. Apex's pre-filing due diligence report, entered as Exhibit A, showed clearly that before filing they had accessed Ray Callaway's current deed, current survey, and current assessed value. All of that information reflected his present address. The address he had lived at since 2010. The address on file with Cascade County since 2010. The address any reasonable search would have returned. The decision to use a rental address from 2012 that Ray Callaway had vacated 14 years prior was not the result of a database lag or a research limitation. It was a deliberate choice made by people who had the correct information in front of them and set it aside. Second argument, the affidavit. Apex had submitted a paralegal affidavit claiming that county records listed the 2012 address as current at the time of filing. Susan entered county records documentation as Exhibit B. The records showed my current address had been on file since 2010. The affidavit was not a matter of interpretation or competing data sources. It was wrong. Demonstrably, documentably wrong. Susan said she would leave it to the court's judgment whether that wrongness was negligent or intentional. Third argument, the Patterson co-filing. The easement claim rested on a foundation of alleged historical access rights that Bob Patterson had represented to Apex in their property sale agreement. No recorded document associated with that parcel, going back to its original deed, contained any access agreement, easement, or right-of-way across the adjoining Callaway property. The access rights Patterson had sold to Apex had never existed. The claim built on top of them had no legitimate foundation. She sat down. Judge Hicks made a single note. Then he looked at Hargrove's table. Counselor. Hargrove stood with the unhurried confidence of a man billing at a rate that makes unhurried confidence affordable. He acknowledged the court, acknowledged opposing counsel, and began. His core argument on the notice question was that Apex had relied in good faith on address information obtained through standard research channels, and that any discrepancy between that information and current county records reflected an administrative propagation lag that was outside Apex's control or knowledge. He used the phrase, good faith reliance, 4 times in the first 6 minutes. He argued that the standard for constructive notice under Montana law did not require absolute certainty of delivery, only reasonable effort. Apex had made reasonable effort. The result was an unfortunate administrative discrepancy, not fraud. On the affidavit, he argued that the county record Susan had submitted reflected a subsequent update, and that the data environment at the time of filing had been less clear than it appeared in retrospect. On the Patterson co-filing, he argued it was a separate matter entirely, a question of contractual representation between 2 private parties that had no bearing on the procedural validity of the easement filing before the court today. He was polished. He was thorough. He had clearly prepared for every counter-argument Susan had made and had a response ready for each one. He was 24 minutes in when Judge Hicks raised one hand. Hargrove stopped mid-sentence. The courtroom went very still. Judge Hicks took his glasses off and set them on the desk. He looked at Hargrove with the patient, level attention of a man who has already located the problem and is deciding how directly to name it. "Counselor," he said, "I want to make sure I understand your position correctly." He tapped Exhibit A with one finger. "This due diligence report, prepared by your client's own legal team, 2 weeks before filing, contains Mr. Calloway's current deed information, his current survey, and his current assessed value. All of it current. All of it accurate." He paused. "And your position is that the same team that produced this report then used a 12-year-old rental address for notice because of an administrative database lag?" Hargrove straightened slightly. "Your Honor, the research process involves multiple data sources and—" "I understand how research works," Judge Hicks said. He put his glasses back on. "I'm asking about this specific document and this specific decision. Are you telling me that a legal team that had Mr. Calloway's current information in front of them accidentally used an address he hadn't lived at since 2012? The room held its breath. Hargrove opened his mouth, then closed it, then opened it again. "Your Honor," Hargrove said carefully, "we maintain that the address was obtained through a research process that was conducted in good faith and that any—" "You've said that," Judge Hicks said. "Just that. 3 words, flat and final, the way a door sounds when it closes on a conversation that is over." He looked at Susan. "Counselor, Exhibit C, the internal communication. Walk me through it." Susan stood. Exhibit C was what she had obtained through the discovery process in the weeks following Apex's initial response. An internal email chain between 2 members of Apex's legal team, dated 8 days before the filing date. She had described it to me twice in her office. Hearing it read aloud in that courtroom, in that quiet, was a different experience entirely. She read the relevant section. A junior associate had written to the supervising attorney flagging the address discrepancy. The associate had noted specifically that the address listed for notice did not match the address reflected in current deed records, and asked whether the filing should be updated before submission. The supervising attorney's response was 6 words. "Use the address from the research file." And below that, 3 more. "We're on a timeline." Susan set the document down and sat. The room was completely silent. Not the held breath silence of before, something heavier than that. The silence of a room where something has just been settled and everyone present knows it, including the people on the losing side. Hargrove's team conferred in low, tight voices for about 40 seconds. Then Hargrove stood and began to explain that internal communications needed to be understood within their broader operational context, that timeline pressures related to permitting deadlines created communication shortcuts that did not reflect deliberate legal strategy, that a single email exchange was not sufficient to characterize the entirety of— Judge Hicks raised his hand. Hargrove stopped. The judge looked down at his papers. He made 2 notes, slow and deliberate. He took his glasses off and set them on the desk. He sat back in his chair and looked at the middle distance for a moment. Not at either table, not at the gallery, just ahead. The look of a man completing a thought he started before he walked into the room this morning. Then he leaned forward. "The court finds as follows," he said. His voice was even. No performance in it. Just a man reading the conclusion that the facts had written for him. The notice of prescriptive easement claim filed by Apex Land Holdings against parcels 7, 9, and 11 of the Callaway Property Trust in Cascade County is void ab initio, invalid from its inception, on the grounds of fraudulent notice. The internal communication entered as Exhibit C establishes without reasonable alternative interpretation that the decision to use an outdated address was deliberate. Mr. Callaway received no valid notice. The filing is vacated in its entirety. He paused. One beat. The court is additionally referring the conduct of Patterson Land, LLC and its principal to the Cascade County District Attorney's Office for review of potential misrepresentation in the associated property transaction. That referral will be entered into the record today. Another pause. The secondary encroachment claim filed by Apex Land Holdings is dismissed without prejudice. Apex's survey methodology is insufficient to support the claim as filed. We're adjourned. The gavel came down. Hargrove's team began gathering their materials with the quiet efficiency of people professionally accustomed to composing themselves after bad outcomes. No raised voices, no visible reaction. Just 4 attorneys and a paralegal packing leather portfolios and rolling briefcases toward the door without looking at our table. I sat where I was and didn't move for a long moment. Susan put her hand briefly on my arm, a gesture she hadn't made before, not her style, and then turned to organize her documents. Methodical, unhurried. I looked at the bench where Judge Hicks had been sitting 60 seconds ago. It was empty. He didn't just reverse it, he erased it, like it never existed. I drove home alone. Susan had offered to get lunch, a quiet celebration, just the two of us, nothing elaborate. I thanked her and told her I needed to get back to the property. She understood without me having to explain it further. That was one of the things I appreciated most about Susan Greer. She never needed more explanation than you gave her. The drive back from the courthouse takes 40 minutes on a good day. I don't remember most of it. I know I stopped at the gas station at the county road turnoff and bought a coffee I didn't finish. I know the sky had gone that particular flat gray that comes in late October when the season is fully committed to itself. I know I had the radio off the whole way. I just drove. Apex filed no appeal. Susan told me 3 weeks later, matter of fact, no fanfare. The DA referral on Bob Patterson had made the case too toxic to pursue further. An appeal would mean more discovery, more internal communications potentially entering the record, more scrutiny on a legal team that had already watched a judge read their emails aloud in open court. Whatever calculus Apex ran on the risk, the answer came back the same way it always does for corporations when exposure outweighs the prize. They walked away. Bob Patterson sold his remaining Montana properties quietly over the following 2 months. I heard about it secondhand. Jim Holt mentioned it one morning, the way you mention something you're not sure how the other person will take. I didn't say much. Bob was gone, and the 12 acres he'd sold to Apex reverted to a holding company that had no active development interest in it. It just sat there. 12 acres of scrubby eastern boundary land that nobody was doing anything with. Same as when I'd sold it to Bob 8 years ago. I won't tell you the aftermath felt the way I thought it would. I had spent months imagining what it would feel like when it was over, when the filing was gone and the claim was vacated and the corporation had packed its matching briefcases and driven back to Denver. I had imagined relief, maybe something close to triumph, the satisfaction of a thing resolved. What I actually felt, walking this land the evening after the hearing, was quieter than that, and heavier. The fight had cost something. Not money. Susan's fees were real but manageable. What it cost was harder to quantify. Months of broken sleep. The particular fatigue of carrying something unresolved for a long time. The loss of a trust I hadn't known I was placing in Bob Patterson until I found out what he'd done with it. The weeks of pressure from people I respected who thought I should take the money and be done with it, not because they were wrong to say it, but because hearing it over and over had required a kind of resistance that wears on you even when you're certain you're right. None of that goes away because a judge rules in your favor. But I walked the north pasture that evening anyway. Parcel 7, the northwest meadow where Apex had planned to run their private access road. The 40 acres I'd cleared with a brush cutter over 3 weekends in the spring of 2022, alone, my back aching for 2 weeks after. I walked the full perimeter in the fading light, and I thought about Earl Calloway paying $11,000 cash for 200 acres of Montana grassland in 1963. I thought about Gene Calloway taking out a loan in 1979 and paying it off in 6 years. I thought about what it means to be the third person in a line of people who kept something intact. My grandfather never filed a legal motion in his life. He didn't have to. He just worked this land, year after year, season after season, until it became part of us in a way that no easement claim and no corporate timeline and no rolling briefcase full of legal documents could undo. No corporation gets to erase that with a form and a wrong address. 3 days after the hearing, I did something I hadn't done in almost 2 years. I called my son. Danny Calloway is 31 years old, lives in Missoula now, works in civil engineering, comes home maybe 3 or 4 times a year. He knew the broad shape of what had been happening. I'd told him enough to keep him informed without pulling him into the weight of it. He knew about the filing. He knew about the hearing. He knew it had gone our way. What he didn't know was what I wanted to tell him now that it was over. He picked up on the second ring. I told him to come out to the property that weekend if he could manage it. Told him I wanted to walk the north parcel with him. He said he'd be there Saturday morning. He was. 7:30, same dark green truck his grandfather would have approved of, pulling up to the gate the way Jim Holt does. Engine you hear before you see it. We didn't talk much on the walk. That's a Calloway thing. We covered the full perimeter of Parcel 7, the northwest meadow, the 40 acres I'd cleared in 2022, the ground Apex had drawn a road through on paper and never set foot on in reality. The frost had come in hard the night before, and the grass was stiff and silver in the morning light. At the far northwestern corner, the exact boundary line where Apex's planned road would have entered my land, I stopped. Danny stopped beside me. I didn't make a speech. I'm not built for speeches. I just stood there for a moment looking at the ridge line and the sky above it, and the grass running all the way back to the house. Then I pulled a new fence post from the back of my truck and drove it into the ground at that corner. Solid. Plumb. Right where the line was. Danny watched me set it without saying anything. Then he picked up the second post I'd brought and drove it in 6 feet down the line. We worked in silence for 2 hours, fixed every loose section on that entire northwestern boundary. When we were done, we walked back to the house and I made coffee and we sat at the kitchen table where all those documents used to be stacked and talked about nothing important for a long time. That was the resolution. Not the gavel, not the ruling. This. That was 14 months ago now. The Ridgeline Reserve project stalled completely 6 weeks after the hearing. Without the access corridor through my land, Apex's private road network had no viable route to the county highway. The permits they'd spent 18 months securing became worthless. Last I heard, they'd quietly listed the 1,200 acres they'd acquired up north with a commercial real estate broker out of Billings. 1,200 acres of Montana land they'd bought to build a luxury resort on, sitting empty. Jim Holt told me about it over coffee one morning, same kitchen table, same chairs. He had that look on his face. Not quite a smile, something more understated than that. The look of a man who watched something get corrected and finds quiet satisfaction in the correction. I know that look. I've worn it myself. Bob Patterson's conduct was reviewed by the county DA. I won't go into the details of what came from that process. That's not my story to tell. What I will say is that the 12 acres he sold to Apex eventually transferred to a young couple from Great Falls who run a small hay operation. They're good neighbors. They wave when they pass. That's all I ever needed from that piece of ground. Here is what I know now that I didn't fully know before all of this started. Land doesn't protect itself. A clean title is not a shield. A recorded deed is not a guarantee. The systems that are supposed to protect private property work, but only if someone is paying attention. Only if someone catches the thing that shouldn't be there and refuses to let it sit. My grandfather Earl paid cash for this land because he believed ownership meant something permanent. My father Gene borrowed money for it and paid it back in 6 years because he believed the same thing. I spent the better part of a year fighting a billion-dollar corporation in county court because I am my grandfather's grandson and my father's son, and I did not know how to do anything else. The land is still here, all 600 acres, every fence line, every creek bend, every patch of rocky ground I've known since I was 12 years old. Parcel 7, Parcel 9, Parcel 11, mine. If you own property, land, a home, anything with your name on a deed somewhere, I want you to do one thing before you go to sleep tonight. Pull up your county recorder's website, search your name, read what's there. It takes 10 minutes. The corporation that filed on my land was counting on the fact that most people never do it. Don't be most people.